Good morning. Welcome to the October session of the Court of Criminal Appeals. I'd like to start just by introducing you to the panel that's going to be before you today. To my right, Tom Greenholtz from Chattanooga. To my left, Matt Wilson from Jackson. And I'm Bobby Holloway from Columbia. As most of you know, each side will have 20 minutes. If the appellant wants a time for rebuttal, if you'll let me know at the first. We will be keeping the time on the, keeping your time on a timer. Where are those lights? Okay, right there. So you'll see when it goes yellow and then red. Is that how it does? This is my first time in Knoxville with the timer. Okay. Oh, there they are. Okay. Are there any preliminary matters, Madam Clerk?
No, Your Honor.
And I will mention, we have read the briefs. We have not read the transcripts or the rest of the record, but we have read the briefs, so with that in mind. Would you call the first case, please?
State of Tennessee versus Terrance, Terrell, King.
Good morning.
Good morning. Good morning.
My name is Chelsea Moore. I'm here on behalf of Terrance Terrell King on the denial of a motion for resentencing under the amended drug-free zone statute. I'd like to reserve 5 minutes for rebuttal. On February 7th, 2017, at 1:43 a.m., Mr. King was arrested in a motel parking lot with a relatively minor amount of marijuana and a gun that was found in his girlfriend's car, and that charge was later dismissed. Following his arrest, Mr. King was indicted in Knox County. And in February 2018, the weekend before Mr. King was set to go to trial, the state made an offer where he received a 7-year sentence on non-drug-free zone convictions with a consecutive 3-year sentence, the first two at 100% and the third year at 30%, for a charge of possession with intent on Schedule 6 marijuana within 1,000 feet of a private elementary school. Following the plea, the legislature changed the law and created an avenue for post-conviction relief for those who had been convicted under the old law. Mr. King filed a pro se motion for resentencing. The trial court appointed me and granted the request for an evidentiary hearing, and then conducted a new sentencing hearing. The state did not put on any countervailing proof or evidence to suggest that Mr. King should not be resentenced. The state merely argued that since he would have been facing a sentence of 12 years at 100% if convicted at trial, the court should leave the sentence as is. Following the hearing, the trial court found that under the new law, if tried today, Mr. King would not be subject to the drug-free zone enhancement. But the court found that the court could only resentence him to a higher sentence of 6 years at 60%, and that the interest of justice weighed against resentencing because he received the benefit of a plea bargain. I will discuss why those conclusions were in error later, but I would like to start with the jurisdictional argument, cognizant of the fact that the court has decided in 2 cases that a defendant does not have a right to appeal this issue.
I mean, isn't Bobo dispositive?
I do not believe so, in part because according to the footnote, appellant did not argue the merits of the jurisdictional argument.
The footnote also says that even if it had been preserved, though, we would still find that it was waived. Isn't Bobo dispositive?
Well, if I remember correctly, it would have been waived because it was not timely, and this notice of appeal was, in fact, timely.
But the holding in Bobo is that Rule 3 does not grant a right to appeal from a denial of resentencing. That's distinguished from Watson, Mr. Harwell's case, where when resentencing is granted, the right of appeal will lie under Rule 3. But why isn't Bobo not dispositive here on its interpretation of Rule 3?
Well, on one point, with all due respect to this court, I believe that case will go up for appeal, so that decision wouldn't
It's a
be...
reported case now, Supreme Court.
Oh, it has changed?
It was not
Well,
appealed.
then my mistake. I don't believe that I don't believe that it should be dispositive, because I don't believe that this court had proper arguments before it. And my understanding from the ruling is that they didn't argue it at all, whereas this court granted deferral on the state's motion to dismiss to determine the jurisdictional issue based on the analysis of Tennessee Code annotated section 16-5-108A2.
Why don't we take it from first principles? And I'm sorry to interrupt, but why don't we take it from first principles? Do you agree that a right of appeal lies only if Rule 3 allows it to be so?
Yes.
What language in Rule 3 grants the right to resentencing? Or, excuse me, what language in Rule 3 grants a right of appeal from a denial of resentencing?
I believe it could be read in two different places. The first would be in criminal actions, an appeal as of right by a defendant lies from any judgment of conviction entered by a trial court from which an appeal lies to the Supreme Court or Court of Criminal Appeals if the defendant pleads guilty and the issues presented for review were not waived as a matter of law by the plea of guilty or nolo contendere, and if such issues are apparent from the record on the proceedings already had.
Okay, that's the original judgment, right? There is no, unlike Watson, where Watson was a new judgment, you don't have a new judgment here. So your right to appeal, yes, may have taken from the original judgment, but that was a long time ago.
Well, and I would disagree due to the language any judgment, whereas in 3C it's only from an order. I think that it's more inclusive language. Additionally, I think that the later section, the defendant may also appeal as of right from an order denying or revoking probation, from a final judgment in a criminal contempt, habeas corpus, extradition, or post-conviction proceeding. The lack of capitalization of post-conviction proceeding contradicts the capitalization in 16-5-108A2, where it says Post-Conviction Procedure Act proceedings attacking the validity of a final judgment of conviction or the sentence in a criminal case, and other cases or proceedings instituted with reference to or arising out of a criminal case.
Do you think that the reference to post-conviction proceeding in Rule 3, because it's not capitalized, refers to something more broadly than the Post-Conviction Procedure Act?
Yes, because
Even though it also is including in that same language other post-conviction remedies such as habeas?
correct, but it doesn't include something like writ of error quorum nobis, which there is a right to appeal, a denial of writ of error quorum nobis, which is a post-conviction proceeding.
We agree that this is not a Post-Conviction Procedure Act case, though. Is that correct?
No, I believe that he's been convicted and that this is an appeal following a conviction, so it would be a post-conviction
This
proceeding.
is not a case arising under the Post-Conviction Procedure Act, is it?
Correct.
Okay.
Correct. And in addressing those issues, if this court finds that there is not jurisdiction for Mr. King to appeal the trial court's resentencing or decision on the motion for resentencing, then I think that that would violate the court's Rule 1 of the appellate procedure rules, the speedy, just, inexpensive determination, because it would then create the need for defendants to pursue relief through other avenues, other post-conviction avenues like the Post-Conviction Procedures Act or writ of error quorum nobis, or in federal court, this Section 2254 motions. So it would deny the relief on merits and create a potential extensive pipeline of further post-conviction proceedings. And
again, maybe the first principles, and I'm sorry to keep asking the questions. Do you agree that the legislature could rationally conclude that no appeal should lie from a denial of resentencing?
no,
Don't you think it's arbitrary that the legislature could say where a court denies resentencing, leaves the original judgment in place, maintains the status quo, that it's unreasonable then for the legislature not to provide a right of appeal from that?
I do think that's unreasonable, because I think that
You think the Constitution requires the legislature to put in an appellate procedure?
yes, I do.
You do?
Because I think that any application from or of the drug-free zone enhancement would be appealable. If convicted at trial and enhanced under the new statute, a person can appeal that. Therefore, I think that everything within the statute should be appealable.
It could only be appealable right if the legislature provides for the right of appeal or if Rule 3 provides for a right of appeal. I hear you arguing now that the Constitution, presumably the state Constitution, provides a separate right of appeal.
Well, I don't believe that was, I thought your question was whether, well, I'll just answer your current question. I think that under the due process clause, that they created a right and there must be a remedy.
Are you aware of any authority that requires, either state or federal constitutional authority, that provides that a criminal defendant is entitled as a matter of first principles to the right of appeal pursuant to the due process clause?
At this current moment, I cannot.
Factor their cases to the contrary?
I cannot think of, I'm sorry, I did not prepare that issue, so off the top of my head, I could not provide an answer. If you would like post-hearing briefing, I'll be more than happy to do so. But I think that, as I said, the legislature has created the right in the catch-all provision of 16-5-108A2, and then that is also encompassed within 3B. So the principles of Rule 1 would encourage you all to find that there is a right to appeal. And as I said, the trial court did grant a hearing and determined the issue on the merits as to resentencing. They didn't summarily dismiss the motion. They gave him a right to be heard. So the statute, and this court is aware based on Bobo, Billingsley, and Watson, that the statute is being interpreted in different ways depending on which jurisdiction that the person has been convicted in. And that disparity is creating a denial of equal protection for defendants throughout the state. If you're convicted in different courts within Knox County, you're receiving different treatment, as evident by Mr. King's case, Mr. Billingsley's case, and Mr. Watson's case. So I think that this court has an obligation to step in to interpret the statute to allow trial or to provide guidance to the trial courts. Because as in this case, the court determined...
Doesn't equal protection only apply when the defendants are similarly situated?
Well,
Bobo was not similarly situated to Watson. And so I would expect that there would be differential treatment in that case.
I guess equal protection in the sense that they are all defendants convicted under the old drug-free zone statute, and
But they're not similarly situated because Bobo was denied the right to resentencing, whereas Watson was granted a new sentence and a new judgment. They're not similarly situated, are they?
Fair, in that way they are different.
Okay.
However,
so the equal protection clause then would not apply, would it?
well, I guess I'm comparing, I should have been more precise. Mr. Billingsley and Mr. King are more similarly situated, and Mr. Watson is similarly situated to those two. So the three from Knox County are more similarly situated. Of course, I did not represent Mr. Billingsley or Mr. Watson, so I don't know the underlying facts of that case as well as Mr. King's. But having been convicted under the same statute, given a hearing, and then reading the trial court's denial of resentencing in Mr. Billingsley's case and Mr. King's case, it's different than that of Mr. Watson. In Mr. King's case, the court found that the drug-free zone statute would not apply, but that he received a benefit of the plea bargain at the time, and that the court was bound by what the court presumed was Mr. King's sentencing range. Without the state filing a notice of enhancement or intent to seek enhanced punishment, and without certified copies of the judgments before the court determined that the court had the only option was to resentence Mr. King as a career offender, which would be a 6-year at 60% sentence, which would be greater than the 3 years with the first 2 at 100 and the third at 30. The trial court read into the statute beyond what the plain language stated in determining that the court was unable to resentence Mr. King under the terms of the original plea agreement, which would be an E-felony as a range 1 offender, because it would not have been increased to classification, and he wouldn't be sentenced at 100%.
Ms. Moore, let me ask you this. This resentencing act that the legislature has enacted, to me, seems to be to provide trial court judges who sentenced defendants under a, let's say it's a school zone case, to 15 years at 100%, we'll say, which was the minimum. And it may have been, the facts of that case may have been that the school was closed, or that they just drove by, or the 1,000 feet you had to fly, go as the crow flies when you couldn't get there the other way. And the legislature was trying to give those trial judges the discretion, if they chose to modify those sentences. And the key word there to me is the discretion. How did the trial court in this case, let's assume you have a right to appeal, which, at this point to me is just an assumption. How did the trial court abuse its discretion in this case, which he has to look at the particular facts of, and to say, no, I'm not going to grant it in this case?
Well, first, I believe that was the legislature's initial intent, but the subsequent amendment granting the retroactive right to appeal for those convicted under the old law demonstrates that the legislature also intended to correct past injustices.
Right to appeal or resentencing?
Resentencing.
Okay.
Why are we looking to legislative intent? Aren't we to apply the words of the statute rather than some kind of mythical intent that we would assume that a legislature would have had?
And that goes into why the trial court abused its discretion in this matter, is that the trial court read into the statute beyond the plain language to interpret it broader than what the legislature passed in the statute. So since the trial court went beyond the plain language of the statute, I think the legislative intent is relevant now.
Why are we talking about legislative intent?
It's the purpose of the statute. It's the reason that we're all here. The intent was to correct past injustices and to grant relief to those that were punished unfairly under the old law. But
so maybe that's the issue here. We won't rest on it a little bit, but you're ascribing an intent. I think the Supreme Court in a couple of cases now has said that when we're interpreting statutes, that we need to interpret the language of the text in accordance with what a reasonable person would have understood at the time of the enactment. I'm hearing you say that we need to ascribe to the legislature an intent or a purpose that's written nowhere in the statute and is maybe being ascribed here today for the first time. Why would we look to a legislative purpose or an intent instead of just the words of the statute?
Well, and I may have gone too broad with my legislative intent explanation, but I think that the plain language of the statute, read by a reasonable person, can be interpreted as the legislative intent was to correct convictions under the old law, which were harsher. So they want to allow people to be resentenced under the less harsh law and receive lower sentences. So to me, the legislative intent is to reduce sentences under the old law that they found to be improper.
Before you're getting into your rebuttal time, if you want to go ahead, you're welcome to, or if you want to save some for rebuttal.
Well, I'd like to save it for a rebuttal, but I'd also like to address your question about abuse of discretion super quickly. I already noted that he incorrectly interpreted the statute beyond the plain language to determine that he was only allowed to sentence Mr. King under presumed range and not under the terms of the plea agreement as originally entered. But additionally, his analysis of the interests of justice focused primarily on the terms of the plea agreement and the benefit that he received under the initial law. The trial court's determination that he was only allowed to resentence him as a career offender, and that he didn't deserve resentencing because he had received the benefit of a plea bargain, and the trial court's beyond that interpretation of what could have happened including more time on a conviction or on a sentence, or excuse me, more time on a count that was dismissed, the court just went far beyond the scope of what the statute contemplates, and that is why the court abused its discretion. But I will reserve the rest of my time for rebuttal. Thank you.
All right, thank you, Ms. Moore. Mr. Groves? General Groves?
May it please the court, Alan Groves on behalf of the state. Judge Greenholz, I think you're right that this court's decision in State v. Bobo, which has now been published, is controlling with respect to Rule 3. I'll grant that the defendant in this case has raised some additional arguments as to why an order denying a motion for resentencing might fit within Rule 3 that weren't advanced in Bobo. But as I read Bobo, the court's holding was pretty categorical in stating that Rule 3 simply does not cover these types of orders. So presumably the court considered each of the enumerated types of orders listed in Rule 3 and concluded that none of those types of orders would fit this particular situation.
Does the Drug-Free Zones Act itself grant a right of appeal from a denial of resentencing?
No, Your Honor.
And so Rule 3 doesn't grant a right of appeal. Does the Constitution independently grant a right of appeal where the legislature has not provided one and where Rule 3 does not also provide for a right?
No, Your Honor, I apologize. I believe the United States Supreme Court and the Tennessee Supreme Court have both held that all types of collateral review are not constitutionally compelled. So that's completely within the legislature's discretion whether to even provide a form of collateral relief, whether it be habeas or post-conviction. So there's certainly not a right of appeal from those actions.
In fact, for maybe the first 100 years of the Republic, we didn't have a right of appeal in federal criminal cases. That would, at least in my mind, tend to weigh against an argument that the Due Process Clause somehow compels it.
I think so. I agree with that, Your Honor. And certainly, as you mentioned, this is not a judgment of conviction. So this argument that the defendant didn't waive issues when he pled guilty is not relevant because it's not a judgment of conviction. It's just an order denying a motion for resentencing. It's also not an order denying probation. It's an order denying resentencing in total. So even though there might have been a request for probation, we don't really get there because the motion for resentencing was denied. And then finally, this argument that it's a judgment related to a post-conviction proceeding, I reject the defendant's characterization of that as relating to all types of orders that are collateral in nature. Because as Your Honor mentioned, it specifically enumerates habeas and other types of collateral proceedings. With respect to error quorum nobis, there's a separate statutory right of appeal for error quorum nobis. So the right of appeal for those types of cases is not derived from the post-conviction language in Rule 3. It's derived from the statute. The same would go for intellectual disability petitions in capital cases. There's a separate statutory right of appeal. And so as far as I'm concerned, my understanding from this court's order before we reached the merits briefing was that the only reason the court didn't dismiss the case when we filed a motion to dismiss was because the defendant's principal brief also relies on this court's jurisdictional statute, which is TCA 16-5108. And the language there reads that this court has jurisdiction in habeas corpus and post-conviction procedure act proceedings attacking the validity of a final judgment of conviction or sentence in a criminal case, and here's the operative language, and other cases or proceedings instituted with reference to or arising out of a criminal case. And so the defendant seemed to be suggesting in his principal brief that that latter language would just encompass any judgment, any order in any criminal case whatsoever. And my understanding from the court's order was the court wanted us to address that specific statute since Bobo has already decided the Rule 3 issue. And I think we can do that in fairly short order because in Adler, the Tennessee Supreme Court specifically overruled this court's decision in McCary, which held that the jurisdictional statute apparently anticipates that all final judgments arising out of criminal cases are appealable. The Supreme Court overruled that decision. It arose in the expungement context where, at the time, Rule 3 did not provide for an appeal from an expungement order, and this court had held that perhaps this jurisdictional statute is broader than Rule 3 and would just kind of act as a catch-all provision. And the Tennessee Supreme Court came in and clarified that, no, it's not a catch-all provision. It's really only vesting the court with the jurisdiction in any case in which a rule or statute has already authorized an appeal as of right.
I want to ask you about the contention in appellant's reply brief about the writ of certiorari. Okay. You didn't have a chance, or the state didn't have a chance to address that, correct?
Correct. That was raised in the reply brief.
So it wasn't brought up in the response to the motion to dismiss by the appellant, correct?
Not that I recall.
Or do you believe it's waived?
Typically, arguments that are first raised in reply briefs are waived. I have come across a published opinion from this court, State versus Leith, I believe, from 1998, where the court said that it had inherent power to construe an improperly filed Rule 3 appeal as a writ of cert, as a petition for a writ of cert. But even if that were the case, I think it would be within this court's discretion to do that. I don't think any legal principle would compel the court to address that issue. And I also think it's entirely meritless to treat this as a petition for a writ of cert, because the Supreme Court has explained that that remedy is an extraordinary judicial remedy that only applies in narrow circumstances. And it's typically raised when the trial court is alleged to have exceeded its jurisdiction in some way, acted illegally, completely denied a defendant his day in court. And here, the defendant's really only challenging the trial court's exercise of its discretion to deny resentencing. There's no claim that the court exceeded its jurisdiction or denied him his day in court. He had a hearing, and there's no contention that the court acted illegally either. It just reached a different result than the defendant would have preferred.
I mean, the Drug-Free Zones Act itself says that nothing in the resentencing statute shall be construed to mean that someone has a right to resentencing.
Exactly. It's completely discretionary with the court to grant resentencing. So I really don't think the petition for a writ of cert would be applicable here. And I think a good example of that, Your Honor, is in the Adler decision, which I previously mentioned, which dealt with the expungement order and whether that was appealable before Rule 3 was amended to include that as an option to appeal. In Adler, the court did treat the appeal as a petition for a writ of cert, but that was because the state in that case was arguing that the trial court lacked jurisdiction to expunge in that case because the defendant had been acquitted of a greater offense and convicted of the lesser offense, and the defendant was wanting expungement for the greater offense. So the state's argument, which was ultimately rejected, but the point is that the state was arguing that the trial court lacked jurisdiction. So that's the only reason the Supreme Court treated the appeal in that case as a petition for a writ of cert, which is completely different than this case when there's no argument that the court exceeded its jurisdiction in any way. Just a couple other things that were raised in the reply brief, Your Honor, that I didn't have a chance to respond to in my responsive brief. The defendant mentions at one point trying to distinguish these other cases where the Supreme Court has repeatedly found that orders that are not enumerated in Rule 3 just don't have a right of appeal. The defendant tries to distinguish those by saying, well, in those types of proceedings, you don't have a statutory right to be represented by counsel. And under the Drug-Free Zone Act, you do have a right to an attorney in these resentencing proceedings. But there's no citation to authority in the defendant's brief that suggests that simply because you have the right to an attorney at a particular stage of a case, that automatically entitles you the right to an appeal. The only statute that the defendant cites is that when an attorney is appointed to a defendant, that attorney has to represent the defendant upon any appeal from the judgment, which is 40-14-203. But the word any in that very statute presupposes that sometimes the defendant either doesn't want to appeal or cannot appeal. So that statute doesn't support the defendant's position either. I believe I've addressed all the arguments I wanted to make about the right of appeal in this case. If the court's interested in delving into the merits a little bit, I'm happy to answer any questions, but we think that the trial court pretty clearly did not abuse its discretion in finding that the interest of justice weighed against resentencing here, given the defendant's extensive criminal history, admitted disciplinary infractions in prison, and the favorable plea agreement.
So your friend on the other side would suggest that the trial court improperly considered the fact of a plea agreement in the case. What if you have a situation like this, where as part of the original plea, just hypothetically, as part of the original plea agreement, the defendant agrees to plead guilty to an offense, except a drug-free zone enhancement. In exchange, the state agrees to dismiss several other charges that are currently pending against the defendant as part of its give and take in the negotiations. Also agrees to recommend to the trial court that the defendant receive the minimum sentence under the drug-free zone case. So the state is giving valuable consideration in exchange for what it believes will be a minimum sentence under the drug-free zones case. Is it permissible then for the trial court on a resentencing hearing to look back at the original plea agreement and say, if I were to grant the defendant a benefit here, I cannot grant a corresponding benefit back to the state? I mean, the state gave up a lot of consideration for the original plea agreement. Could the trial court, within its discretion, consider the fact of the plea agreement and the state's concessions and its inability to give any benefit back to the state as a reason for denying resentencing?
Absolutely. The Drug-Free Zone Act explicitly, when it outlines discretionary factors the court can consider in analyzing the interest of justice, it specifically mentions the circumstances of the plea agreement, and I think that cuts both ways. There's no limitations in the statute on what the court can consider. Even those enumerated factors are not exclusive. So I think the court could consider almost anything it wanted to in evaluating where the interest of justice lies. It just can't impose a greater sentence in the end. If there are no further questions, we respectfully ask the court to dismiss the appeal and, in the alternative, affirm the judgment of the trial court.
Thank you, Mr. Groves. All right, Ms. Moore.
I'd like to start by addressing something that opposing counsel just stated, that the trial, well, I guess rebutting him. The trial court's retroactive review of a plea agreement must consider the state's bargaining position under the new statute, whereas it was previously, the state was previously in a position under the old statute. So like in Mr. King's case, he was facing 60 years at 100% when he received this plea agreement. Under the new law, he would be facing 30 years at 60%, or if the state presented evidence of his career offender status. So the state would be in a different bargaining position at present than they would have been when the plea agreement was negotiated. And I think that that is an important factor in terms of the court's analysis. I would also like to correct opposing counsel's characterization of the court's judgment. The court ruled that the court analyzed every factor, but the court ruled that the interest of justice, and this is from page 23 of the transcript, I would find that the interests of justice do not warrant a resentencing primarily because he got a plea deal. That was a great deal, that he was looking at a lot longer sentence. And then the court expands on the court's general view that look at the factors in order to determine whether or not it's in the interest of justice. Was it a trial or a plea deal? And so these plea deals, what I'm looking at, did they plead and take basically what they would have gotten had they gone to trial, or did they plead as charged, or were there a bunch of things that were reduced? And so to me, it's the folks like a separate defendant and other folks that go to trial, get popped, and end up doing like 30 years at 100%, where it would have been like 8 at 30% had the law been changed. Those are the folks that I think the interests of justice really dictate for. So once again, the trial court was reading more into the statute to deny people who had received the benefit of a plea bargain the right to appeal, or the right of resentencing.
Isn't he just saying, though, that he thought it remained a good deal? Isn't that what he's really saying?
Well, I suppose, but throughout his analysis, he references the 60 at 100% and the gun charge that was dismissed. The gun was found in the vehicle owner's vehicle, and she had a receipt from purchase days prior. So the gun was not found on Mr. King. There was no evidence that he ever actually possessed it. At best, he was in constructive possession, but ultimately, it was hidden within the car that he was a passenger in, and it was hidden within the owner of the firearms car. So the gun charges, I don't think, merit. I think the gun charges lacked merit and wouldn't have rendered a conviction at trial.
Okay. In your remaining time, do you want to address why we shouldn't find your writ of cert argument waived?
Well, I guess the procedure was new to me, responding to a motion to dismiss. While I did cite various issues or various grounds in my reply, once the court directed me to brief in my reply brief the avenues for appeal or the right to appeal, and I was able to conduct more research, I discovered that issue. I think that is equally reasonable for the state to predict, and they had an opportunity to address today. But
So
ultimately,
on what ground then do you seek the writ? So, for example, your friend on the other side says the writ will lie in cases where a defendant has not received a hearing. Your client received a hearing. The writ will lie in circumstances where the trial court acts outside of its jurisdiction. The trial court didn't act outside of its jurisdiction in this case. I don't even think that Mr. King is asserting as such. Where does the writ lie?
I could turn to the right page. I would focus primarily on the last portion of the sentence in the judgment. There is no other plain, speedy, or adequate remedy. If the trial court abused its discretion, read into the statute more than what the plain language entails, and there's no other remedy for appeal, then it would be appropriate under that section. The court acted illegally by improperly expanding the statute beyond the plain language.
All right, thank you. I
Thank you.
appreciate you being here today, both of you.
Ms. Moore, thank you. General, thank you.
All right, call the next case, please.